Good afternoon, ladies and gentlemen, and thanks very much to ADA for this invitation to speak this afternoon. As Jess and Margaret have both said very clearly, 2019 has got off to a very good start for what we could call the traditional notion of the copyright domain, which includes, works where copyright has expired. And so what better place to start than that legislation changing marmalade recipe by Captain Cook. And of course here in the National Library we can also find Jane Austen's handwritten letters held by the library and many other wonderful things that we are now able to put up on screen, reproduce and do other things with. But I want to suggest that to some extent in answer to Margaret's question about what's understood about the meaning of the public domain, that we need to adopt a much broader notion and more modern notion of the copyright public domain. And if we say, as David Lindsay and I argue in this book, and many other scholars have said similar things before us, that the public domain includes all the uses that we can legitimately make of works and their subject matter without obtaining the permission of a copyright owner, then we have a much richer notion of the public domain. And of course, there is much more for organisations like ADA to value, to defend and to work to extend. And the analysis that David and I did came up with no less than 15 logically distinct and significant categories of the public domain, many of which are pretty obvious and some of which are not so obvious, and numbers 13, 14 and 15 fall into the not quite so obvious category, and I'll return to those a little later. But first, the question we were both asked to look at primarily is, why do we value the notion of the public domain? And Tom has spoken about this very eloquently this morning, and so has Margaret. I would sum up by saying that the broad view of the public domain makes it easier to reveal that there are many of our values that the public domain supports and enhances. And these include, most obviously, creativity, that creators inevitably draw on the public domain to create new works. And so there is a virtuous circle of the content of previous creative works feeding new works. And we'll see examples of that in the final session this afternoon. It's also essential to our acquiring knowledge through educational uses, through study elsewhere. It's the basis of our cultural participation at all levels. Freedom of speech and communication can't always and shouldn't always be subject to another person's permission just because they've used the expressions before that you now wish to utilise, argue about, criticise, etc. And democracy itself depends upon all these relatively uninhibited flows of information contributing to our public discourse. So I'd say we can end up arguing that both individual autonomy and our public life are enhanced by all of the elements that make up the public domain. But having said that, I want to immediately say that the proprietary domain, the works protected by copyright, are just as important in advancing all of these values. The point is that the balance between copyright protection and the limits are imposed by the public domain on the boundaries of copyright protection needs to be maintained. Now, if we're talking about celebrating the public domain this afternoon, or some would say the commons, it's people who make ideas work and give real substance to them. And I thought perhaps one of the best people to start with in any celebration is Elinor Ostrom, winner of the Nobel Prize for Economics, by showing that careful and principled governance could defeat the alleged tragedy of what was supposed to be the overuse and neglect of land that was held in commons or other common pool resources. And she showed that was not always so, and that good governance and organisation could defeat that. And the same approach can apply to commons in information, which is what we're interested in here, through careful governance built on copyright law and built on its institutions and new institutional structures. And those categories of ours, 13 to 15 I mentioned, will illustrate that. To start with, perhaps the clearest example is that of what we'd call neutral voluntary licensing, by which we mean free and open source software licensing developed since the 1980s, and open content, particularly since under Creative Commons licences since 2001, but other open licences as well. Between them, these two developments have caused a vast expansion of the public domain, a vast amount of freedom to use valuable works. But that has all been based on copyright continuing to exist in the works that are licensed, and on the vigilant curation of those licences and their amendment from time to time to make them work better, and active protection of the licence conditions through litigation by Creative Commons, Free Software Foundation, OSI and other organisations. And that's all worked wonderfully. But one of the interesting things is it's had almost no recognition or assistance from legislation. Voluntary licensing, open licensing, is not recognised anywhere in our copyright legislation. And although we heard a lot of the dark side of the EU's Copyright Digital Single Market Directive this morning, about Article 13, there are nevertheless scattered throughout the drafts of that directive some really valuable elements which will facilitate legal recognition of voluntary licensing if the EU picks them up. I've mentioned them there, but I won't go into details of them now. There are many people around this room who you could say are Australian heroes of the public domain, but it's too invidious to mention locals. So I'll just say, hats off to Larry Lessig and Creative Commons, and a great deal of respect to Richard Stallman for his 40 years of persistent pursuit and defence of his ideals. A second aspect of this broader notion of the public domain is, I think, and we've argued in our book, compulsory licensing. Now, Australia has more statutory compulsory licensing than most countries in the world. We have less use of extended collective licensing, or ECLs, than occurs in much of Europe, but both of these are aspects of the public domain. We all obtain great benefits as end users of the works covered by these licences, even though, directly or indirectly, we have to pay. We get to use works that we would not otherwise have had such direct access to in education, culture and elsewhere. And many of the people in this room do so as the intermediaries that manage those licences to the benefit of the rest of the public, educators, librarians and others. And we may need more compulsory licences in future or extended collective licences to enable more comprehensive use of orphan works, out-of-commerce works, as in Europe, and various aspects of GLAM collections. But if we do move forward to make more extensive use of compulsory licensing, we need better and more inclusive governance of the administration of these parts of the public domain and the institutions, collecting societies, that manage those parts of the public domain. And that more inclusive governance needs to cover the interests not only of the members of the collecting societies, but the non-members whose works are compulsorily used under those licences, and of the users who benefit from them. And there are some interesting things in the EU directive as well about greater transparency required in the exploitation of compulsory licences. And I think this is an area where I know ADA already has a role in looking at these things, but in future it's probably a role that will need to become stronger and stronger. And then finally, one of the reasons Jess asked me to speak was in relation to the de facto public domain of what we'd call of benign uses of works. Now, free access is not in itself open content. Just because it's on the internet doesn't mean it's under any type of open licence. But free access can help create, in our view, de facto public domains in specific areas and generally supports the public domain. But I'm only talking about areas where works are used where this is not against the interests of copyright owners, which is why it's referred to as benign use. And you know, the example that is close to my work is Austlii, of course, and of course NZLI as well. Can't forget that. And most of Austlii's legislation, case law, journal articles, treaties, in fact just about everything on Austlii, is copyright content. It is not open content. But it is in effect free to be used by anyone for pretty much any purposes except in many cases, except republication, and in some cases republication as well. So it is a de facto public domain in Australian law, even though we still have Crown copyright. And this is so now in many countries in the common law world at least. But the reason it works is, as Eleanor Ostrom would say, 25 years of careful curation of a commons that involves many elements, just a few of which I've noted there. Long, carefully developed cooperation with data sources, including courts and legislatures, to secure the data, the flows of data that are necessary to maintain the free access. Taking down content when necessary, often for temporary purposes with case law and with opt-outs for other things like journal articles, blocking general search engines from access to the case law, not profiting from surveillance of users, and having sufficient technological innovation to generate financial stability. It's not quite a recipe, but there are a set of elements that you can say will indicate when the development of a de facto public domain may be successful. And I think that other huge resources, such as the National Library's trove, are a similar combination of some public de facto public domain areas, some areas that are genuinely legally in the public domain, and very careful curation, including takedowns on request.
Here's what I found on the web to maintain the free access.
Thanks, Siri. Yes, all right. Well, that broke my concentration, well and truly, but I think I finished that. I'll just, before my final slide, I'll just digress for a second and say a few days ago that unexpectedly happened, and I said, Siri, please turn Siri off. And Siri said, I'm sorry, I can't do that, Graham. It's a true story. All right, that's an appropriate introduction to my final slide, because I feel I need to, despite, our justifiable celebration of the public domain, I need to finish on something of a modern note of caution. Now, I've said, following on from what I just said previously, about search engines. Since Alta Vista in 1997, all of the general purpose search engines across the internet have created the largest de facto public domain in history, the searchable web, and prior to that, the browsable web. And Google, of course, has been one of the leaders and largest contributors to that inestimably valuable contribution. But from around 2000, after its few years of search for a business model, Google, then quickly followed by Facebook a few years later, invented and still dominate the method of surveillance capitalism, as it has been very accurately called, a mutant strain of normal capitalism, which in my view becomes more intense and more dangerous every year, for reasons explained in greatest detail, 600 pages worth of detail, in Shoshana Zuboff's recent book, just published at the start of this year. And, as someone who's primarily a privacy advocate, this is something that worries me very much and gives me a dilemma. Is free access, which is not free from excessive and unjustifiable surveillance, still a valuable part of the public domain? Or, alternatively, is the extent of manipulation of our lives, and as we've seen with Cambridge Analytica and Facebook, manipulation of democracy, a negation of the liberties that I outlined earlier that are the purpose of the public domain? And I think that's something we need to give serious thought to. And secondly, there's a question then that follows from that of whether digital policy organisations, as I might call them, should always treat those who are responsible for surveillance capitalism as their allies, or should they be keeping that under review? And, for the last 20 years, there's been a pretty unrestrained approach that these organisations were allies. Well, I think we have to give that quite a bit of thought from this point on. So on that slightly unhappy note, I'll thank you for your attention. Thank you.